Hi, my name is Tae Darnell. I'm with Darnell and Gottlieb. Darnell and Gottlieb is a firm that is now primarily dedicated to medical marijuana. Really, my background prior to getting into criminal defense and medical marijuana work was in the entertainment industry, working with a number of different NFL athletes, entertainers, a number of contractual issues, corporate setup issues, which more naturally than you would think plugs into medical marijuana. Henceforth, the criminal defense practice. So, really, I got into medical marijuana. I mean, I think it would be disingenuous to say I've been in it for a long time. Really, I think about 2 years is as long as this industry has really been vibrant and active, and really more since the Holder memo, when I think all of us experienced an explosion of work. So at this point, we represent a number of dispensaries, caregivers, growers, probably in the lines of around 100 across the state, from Montrose County to Kit Carson County. They're everywhere. Recently, we teamed with Sean McAllister, the founder of Sensible Colorado, to form the Cannabis Law Center. So we'll have our attorneys with Darnell and Gottlieb, along with Sean McAllister and a couple other attorneys, working specifically on marijuana-related issues. Right now, we're engaged in a couple of actions. Probably the biggest issue is in Westminster. It started out as an issue much like Centennial. Lauren did some work that helped and assisted us there. While I engaged in a tickle fight with their city attorney for 3 months. Really, the argument, they initiated an ordinance and a ban based on federal law, which has been proven to be unwinnable in certain areas of this state, and I think they realized the same. So for 4 months, we were in a holding pattern. Westminster now has decided to instead go after the 84-year-old landlord of my tenant, citing an urban renewal plan as binding zoning ordinance. The issue here is that really we have to fight this from the perspective that these urban renewal plans or master plans are advisory in nature only. Of course, the master plan has never once been used, that we can tell, for any of the other businesses locally. So we feel pretty confident about that case, but the battle is forthcoming. In addition, we've got some issues in Larimer County that may also involve us suing Larimer County, unincorporated Larimer to be specific, where we have dispensaries in the ground prior to moratoriums and bans. They then sent our dispensaries notice of an intention to enjoin them. We responded stating that they couldn't do that. So they then passed zoning regulations stating that our clients needed to go through special reviews or special exception processes. Some of our clients, this is where it's difficult from a representation standpoint. You can either fight the injunction or you can go through the special review process. As an attorney, it doesn't help me if we cost our clients more money in litigation fees than they could otherwise spend in zoning fees. You know, the concern is that they lose in the zoning component, which we're seeing happening with some of those that we don't represent. So it's my opinion that we'll more than likely be engaged in a fight with them and see where that goes. With regard to HB 1284, I feel like it's The Shining and Jack Nicholson, where he says all work and no play. I've read this thing so many times, as we all have, and I think we probably all spent the last 3 weeks regurgitating what we do or don't know about it to our frantic clients, and I think all of us should be frantic because it's an atrocity, and it's a law enforcement legislative action, and there's no other way to interpret it. It's based on medical marijuana being an illegal drug, and that's the way we have to interpret this and proceed on these actions. We anticipate many lawsuits forthcoming and assisting many of the attorneys up here, and I think the more we get involved, the better. The 70-30 provision, I tend to agree, is arbitrary, and it's one that will go on immediately. Sorry about this. I actually did make some notes. The local prohibitions, I think case law is incredibly clear on that local governments aren't empowered to wholly ban a use or industry within its boundaries, especially when you have a constitutional protection. It subjects local authority to a heightened scrutiny with the courts that actually works in our favor for once. Not much works in our favor in this realm, but we'll go after that one pretty quickly. Felony restrictions, we agree with everyone else up here. It's an issue that we've had clients approach us on. Unfortunately, a number of people engaged in this industry have felony convictions because of this industry and the lack thereof prior to it being in existence. So, and if that made sense to anybody, I'm impressed. Another issue that I think is unique is addressing the issue of cultivation in a locality that is permissive and dispensing it in a locality that is also permissive. Some people are saying that you can't cultivate in a different county. I don't know that I read that, but there is this rumor out there that we're getting calls from people saying that. I have no reason to believe that that is something that people are going to...
For those of you in the back, every attorney up here shaking their head. I don't think any of us have seen that anywhere in this.
This is just one of the urban myths that we're hearing out there right now. So if it's an issue, then it's one that will be addressed. I don't see how it can be enforced. It's a permissive use. The caregiver shared grows is another one. I think that's an unreasonable restriction. Out-of-state restrictions. To give you an example, we were recently contacted by a large company out of Amsterdam. They've asked us to help them acquire 25 dispensaries in Colorado over the next 6 months. So needless to say, there's a lot of money behind that, and they may want to sue on an issue like that. And I think there are other people that have a number of out-of-state investors that are, interested in coming into this industry. Unfortunately, time is of the essence for all of them. So I think that's one that will be sued on incredibly quickly. Limiting the number of patients a caregiver can have, really, I can only read this one way, and really what it is limiting a patient's right to a caregiver. I don't see how you do that. There are very specialized uses of this medicine, which specific caregivers can provide for certain patients. If you make vegan lollipops, and that's all you can use, to me, the special exception that they provide is an unreasonable burden on what we're trying to deliver here. So there are a number of ways we're all going to work together on this. One way we would encourage all of you to get involved is through the ballot initiative process. There are some allowances within that, and if we can get aggressive here early, we may be able to make a difference locally. And ideally, I see us being able to make a big impact in some receptive counties. So I'll be quiet now.